everybody. Welcome to civil society and the collective redress of data protection harms. My name is Maryant. I work at the European Consumer Organization, BEUC. I'm a senior digital policy officer there, and this panel is organized by ISOC France. So thank you so much for the invitation, and I have the honor to be your chair. And so I will introduce the topic, tell you why this is important for BEUC and our members, and what we can do to have improvements at the EU level. So evidence shows that the big majority of consumers don't seek redress individually because procedures are very, very burdensome, they're lengthy, they're costly, and then also very intimidating. So our members have been quite active for many years, not only in this field, but also in others. And in the area of data protection, I may want to highlight two things. One is that 7 BEUC members have issued complaints against Google before their respective DPAs, and this is being under consideration by now, and there are other members that are considering different actions. And then the second highlight is that there are 4 class actions against Facebook in Spain, Belgium, Portugal, and Italy after the Cambridge Analytica scandal. And under the GDPR, there are several possibilities for representative actions, but these are limited. Yeah? So there's a possibility for an NGO like ours to comply, if we comply with certain criteria, to actually bring a complaint before a DPA to appeal this decision and to even bring a judicial claim on behalf of data subjects with or without a mandate, but there's a lot of discretion from member state side. Actually, under the GDPR, you can only ask for individual compensation for both material and immaterial damages if you actually comply with certain conditions. The first one is that you need to have a mandate from a data subject, and the second one is that you can only do that if your member state allows it. So far, actually, very few member states have that. So just to be clear, under the GDPR, there's no option for representing collective interest for compensation. And in fact, actually, there's very few countries that provide workable and consumer-friendly forms of judicial redress. And that's why we wanted to go a step further. For decades, BEUC and our members have been advocating for having judicial collective redress, and there's some hope because currently there's a directive on representative actions in the pipelines. Of course, it's still a proposal, and we're still undergoing legislative procedures, but it's a step forward, or can be a step forward. And in this proposal for a directive, BEUC has several demands, and if we actually achieve them, we could be better off, and we can actually supplement data protection law in this area. So what does BEUC want? First, we want a binding instrument at EU level. The proposal is already a binding instrument with a broad scope of application, including data protection, but also other fields like product safety or passenger rights. We also want a proposal, a directive that covers both material and immaterial damages. We also want legal standing for consumer organizations, of course. We also want an instrument that adapts the loser pays principle. We want actually exceptions for consumer organizations. We also want an opt-out collective redress. What does this mean? This means that we want to have the possibility to launch collective action on behalf of people that are identified or identifiable or non-identifiable victims of a harm without needing to have a mandate for it. Why? Because there's actually studies and evidence that show that only 1% of harmed consumers actually opt in to these procedures. And we also want judges to have an active role to bring safeguards. We also have rules for third-party funding, and we also want this directive to cover both national and transnational cases involving both European and third-party traders. And of course, it's not an easy fight. There are some myths, but of course, fears can be overcome with safeguards. To conclude, we can make a historic difference if this directive on representative actions comes into effect, and if it comes into effect with demands that actually are good for consumers. And there's some open questions, and that's where my fellow colleagues come in. because there are some open questions on cross-border cases at the moment, some questions on strategic litigation, on quantifying damages, on whether it's better to go to court or to the DPA. And so we are going to have this discussion moderated by Julien, who is a lecturer at the Universite Rennes 2, and he's doing research in data protection, surprise, and he's going to soon finish his PhD. We also actually have, as you can see, several panelists. So we have Lucien, who is the Secretary General of ISOC France. We have Karolina from Panoptykon Foundation. We have Alexis from la Quadrature de Nets. And we have Nick, who is a lawyer at JMW Solicitors. Are you ready? Let's start.
So thank you for this introduction. In order to save time, I'm not going to say anything except present the first topic. Yes. So very briefly, each presenter will say a few words actually about each topic. So the first topic is going to be the state of implementation of Article 80 GDPR, which allows the possibility for NGOs to represent data subjects in their different countries. So first, Alexis, Fitzjean, or Coffee is going to talk about Article 80 in France in a few short words.
Yeah, thank you, Julien. Hello, everyone. So in France, you have actually two possibilities. You can go before the civil court, or you can now use the Article 80 of the GDPR that allow the non-profit NGOs to go before the local data protection authority, and that's actually what we did at la Quadrature du Net.
So I'll be completing a bit on the process and the implementation of the law in France. Basically, the bill for the protection of personal data implementing the GDPR in France became a law on June 20th and was published the day after that. The bill is quite interesting because basically it's completed by an ordinance which was issued in last December, which is, supposedly improved the readability of the protection law position, but also modified a few key points in the French law. On the collective action mechanism, well, basically you can go both, as Alexis said, before administrative jurisdictions or before civil courts. In France, the sanction powers of the CNIL were adapted in the framework of the GDPR, and obviously the authority can issue administrative fine. The National Assembly, during the parliamentary debate, introduced the possibility of a collective action mechanism, which allows the reparation of damages in order to allow compensation for material and immaterial damages. The change was expected, as has been discussed for a long time in France. What we call in France the action collective or action de groupe collective action or class action, depending, has been introduced first in France in 2014 for consumer litigation and was completed 2 years later in 2016 and extended to personal data protection. So firstly, the scope of the collective action was limited to the cessation of the violation. It was important to be able to extend it in the framework of the GDPR to improve the effectiveness of the collective action mechanism in France.
Thank you, Lucien and Alexis, for the presentation of the French law. Pass the floor to Nick McAleenan to know more about the situation in the United Kingdom.
Thanks very much. I mean, the position in the UK is obviously that Article 80 was directly implemented, and the debate in Parliament was really whether or not there should be opt-in or opt-out.
Microphone, please. We don't hear anything.
How's that? A bit better. So as I was saying, the Article 80 obviously directly applied, and the debate in Parliament was really whether or not NGO there should be an opt-in or opt-out arrangement, and the Parliament took the decision that it would be opt-in rather than opt-out, following lots of lobbying from various interested parties and NGOs and so on. And so the way it's now reflected in English law is the Data Protection Act 2018, various sections 187 essentially replicates Article 80.1. Section 188 essentially suggests that the government should provide some regulation for the possibility of collective actions. And 189 anticipates that the legislature will reflect in 30 months' time on whether or not Article 80.2, i.e. the opt-out option, should be introduced. But at the moment, there doesn't seem to be a huge appetite on behalf of the legislators to change the opt-in, opt-out arrangement. Obviously, we're in the UK now having to deal with Brexit and what happens in relation to Brexit. And there are various transitional issues being dealt with there. They don't necessarily, as far as I'm aware, really touch on the issue of Article 80 and collective actions and so on. But if anybody knows different, please let me know, because it seems to change every day in the UK. So there are some regulations that are coming, and they mainly deal with issues such as adequacy decisions and things like that, not necessarily strictly relevant in relation to collective actions.
Okay, thank you for this overview of the situation in the UK. So now Karolina Iwanska is going to say a few words about the situation in Poland.
Yes, so I want to differentiate between three situations. So first of all, we have the procedure before the DPA, so the administrative procedure. And in that case, NGOs can represent data subjects, as Article 80 enables them to do that. In addition to that, they can also demand that the DPA start proceedings in a particular case, and also they can join the proceedings that is already going on as a third-party intervener. But at the same time, Article 80.2 has not been implemented in Poland, so there is no way to act without the individual's mandate. When it comes to courts, first we have administrative courts, obviously, where we can file a complaint against a decision of the DPA. And there seems to be an inconsistency in Poland between Article 80, what Article 80 says, and the Polish procedural law, because according to the Polish procedural law, NGOs can file a complaint on behalf of a data subject to administrative courts only if they were already taking part in the proceedings before the DPA. So if they did not take part in the proceedings before the DPA, they can only enter the proceedings as a third-party intervener, not on behalf of a data subject. Again, there is no collective action before deep administrative courts in the sense that there is just public interest to be defended. There always has to be a particular individual to be represented in administrative courts. When it comes to civil courts, the situation is, I would say, the worst because NGOs have no way to act at the moment in Poland. So we do not have the right to represent data subjects in civil courts. Class actions are also limited to particular situations, and data protection cases are not one of them. And actually, the reason for that in Poland, the reason that that organizations do not have the right to represent data subjects in civil courts and ask for a compensation or damages, is that there were concerns that bad NGOs are going to abuse GDPR and get rich, asking civil courts for compensation, which is, in my view, a very ridiculous argument. But this is the case. So I think that's it.
Okay, thank you for these overviews of some national legislations implementing Article 80. Of course, there would be plenty more, but we couldn't have 28 people sitting on one panel. That would have been a bit long. So these these legislations are used to start different litigation, collective litigation projects all across Europe. This has our chair said a few words about this in her introduction. But here we have people who are involved at the moment in different cases. So I will pass the floor to each of them so that they can talk a little bit about their current projects and some updates. I think we're all very keen on hearing news from the Google fine that was a result of action undertaken by La Quadrature, for example. So, but first, let's hear some words from Nick McAleenan, who is representing data subjects in a claim against Morrison's supermarkets. So, Nick,
Thanks.
the floor is yours.
So this is a case that I've been working on for a number of years now, and I'm just going to very briefly give you just a snippet of the background to it. The case essentially involved a disgruntled employee of one of the largest supermarket chains in the UK. And this person, in the course of their work, got their hands on the payroll information for every single member of staff working for that organisation. They were disgruntled, and in an act of revenge, so to speak, on their employer, they decided to upload all of the staff's payroll information. So their names, addresses, salaries, bank account details, national insurance numbers, telephone numbers, and so on, up to the internet. That person was sent to prison for 8 years in the UK, but the employees instructed my firm to bring a claim against Morrison's on the basis that Morrison's should be legally responsible for what its employee had done to them. And this has obviously gone through the court system in the UK. The civil procedure by which we act for all of these employees, at the moment we represent 5,500 employees in the actual proceedings. They're the people who are on the group register, so to speak. We also represent other employees as well, but there's a window for people to join these actions. That window's closed, and so we're going to have to go back to the court to talk to the courts about what should happen in relation to the other employees that want to bring these proceedings. Anyway, we were granted a group litigation order in November 2015. There was then a 2-week trial before the High Court in London, at which the company was held to be legally responsible for what had happened. And what the court decided was that the company wasn't directly liable for what had happened. It hadn't actually leaked all of this information, and it hadn't ordered the person to leak this information. But it was what's called vicariously liable for what had happened. So it was essentially held responsible for the wrongdoing of its employee. Morrison's appealed against that decision, and it went to the Court of Appeal, again in London in October 2018, and again the Court of Appeal upheld the decision. Where we're up to in the proceedings is that Morrison's has applied to the Supreme Court, so the top court in the UK, asking for another appeal. And at the moment, the Supreme Court is considering that application, and we should be hearing any day as to whether or not the Supreme Court has granted permission for a further appeal. Obviously, if they don't grant permission, then the employees will have won at the liability stage. If they do grant permission, then there will be a further hearing, and that will obviously happen whenever the Supreme Court has time in its diary, but probably in the next 12 months. So it's an interesting case in the sense that it's probably the first data breach class action in the UK, and probably one of the first in Europe. And so there's lots of interesting lessons that can be learned from it from a procedural and legal point of view. One of the important issues that the court said was, well, obviously, if you're going to be held vicariously liable for the wrongdoing of your staff, then insurance is an important issue to consider. And it says essentially that is the answer to dealing with disgruntled employees or employees that go off on a frolic of their own, so to speak. The decision also has really interesting issues to consider in terms of monitoring of employees, in terms of user access to data, And also, the one area in which Morrison's was actually criticised by the court in the direct liability complaint was data deletion. So what kind of fail-safes, what kind of safeguards are there in place to ensure that very, very sensitive data is deleted once it's been processed? I just also mention another case which isn't one of my cases, but it's a really interesting case that has been through the UK system, and that's the Richard Lloyd versus Google case. And this was essentially an application to serve proceedings outside of the UK jurisdiction on Google. And it essentially, Mr. Lloyd was asking to represent everybody who was affected by the Safari workaround data breach. This is essentially a form of monitoring of people's internet activity that users hadn't been aware of. And previously there was a case in the UK called Vidal Hall in which damages were awarded to a couple of people. And so this was essentially an attempt to bring a claim on behalf of everybody that might have been affected. And it's a really interesting case, because what it basically says is, in order to bring one of these representative actions, you really got to show that you have exactly the same interest as everybody who you're representing. And in the UK, it was found that this particular individual couldn't be said to represent everybody, because either they hadn't actually suffered the same harm as him, or they'd suffered a different type of harm. Actually, it was described as being officious litigation, and it was essentially criticised really on the basis that although there'd been a non-compliance with the rules, this couldn't be said to have actually led to demonstrable damage or harm. And I think these are issues that other courts around Europe are probably going to have to grapple with, if they haven't already, in their own way. So I just flagged that as another case that's really interesting, and lessons I think can be learned from that particular decision.
Okay, so thank you for the description of the Morrison's case, and indeed this other case, which is quite interesting, the Richard Lloyd versus Google case. So I will now pass the floor to Karolina Iwanska, who is going to talk about some very breaking news, because I think that she's going to talk about things that were announced on Monday, if I'm not mistaken.
Yes.
Yes, okay.
Okay, so let me first start with saying that from an NGO perspective, Panoptykon in particular, we mostly engage in strategic litigation, so things that we really feel need intervention. So we do not have really clients usually, but we are a mission, and we choose priorities. So this is a short introduction to me saying that, in my opinion, when it comes to collective action, there are essentially two aims that these collective actions can have. First of all, it obviously enables individuals, engages them, it makes them feel empowered, and helps them also to enforce their rights without having this burden of having a individual procedure on them. And it also creates a pressure for DPAs or for courts to maybe act faster or give higher fines if this is a big infringement. But the second aim, I would say, is, and maybe a more important aim of collective actions or enforcing GDPR in general, is changing the status quo, so fixing bad practices. And in practice, this aim, I believe, can be achieved also without a collective action, especially in countries where there are procedural obstacles to having class actions, like in Poland, for example. So I'm going to speak a little bit about what we did on Monday. If you were on our panel on Wednesday about uncovering the hidden data ecosystem, then that will be a short reminder and repetition. So to give you a little bit of context, what we do not like at Panoptykon is that when it comes to online data, when it comes to profiling and targeting people, what companies usually tell us when we ask them what they do is they show us only the first layer of this data onion. So what we share, what we put online ourselves. Sometimes they also tell us what we do, so what our behavior is, what we click on, at what times of the day, and so on. But what we do not know is this third and most interesting layer, which is what the machine thinks that we are. So on this basis, on the basis of what we post, what we click, how we do it, who in the view of the machine, who, for example, presents us targeted advertising or political advertising, who are we as a person? And we've tried filing subject access requests to many companies in the online behavioral advertising ecosystem. This is infographic in Polish. I'm sorry, but if you look at the icons, you can see it's a very simplified version of how real-time bidding and online ecosystem works, and it's still a little bit complicated, mildly speaking. But to no effect, really. No company wanted. There are very few companies who actually replied to our requests, and we didn't really get anything that we would be satisfied with. So on Monday, we filed complaints against the actual organizers of this ecosystem as we see them. So Google and Interactive Advertising Bureau, the two entities that create standards, and they call them recommendations, but in fact they are so strong that there is no way to take part, to participate in this ecosystem without using these standards. And coming back to our today's topic, so collective action and enforcing GDPR, it is not a collective action. The data subject in this case is the president of Panoptykon, and she is but we are still using Article 80 because we are representing her as Panoptykon in this case. So only time will tell if I will speak a bit further on the panel about the cross-border and transnational aspects of this case. But only time will tell if it will be as effective as collective action could potentially be. But yeah, this is my input. Thank you.
Okay, so thank you, Karolina, for your presentation on how you in the Polish context and the Polish legal context, you are trying to bring this collective action on this very important topic regarding real-time advertising, but also the question of the right of access, actually, which is also now at the core of the strategy, for example, of none of your business. You just filed also complaints regarding the fact that many data controllers still haven't implemented correct right of access procedures. So now we're going to turn to Lucien Castex, who is going to talk a little about this project called eBestie, which has been launched by the French chapter of the Internet Society.
Thank you, Julien. Well, basically, the eBestie initiative indeed was launched by Internet Society France, and the idea is quite simple. In late 2017, we wanted to mobilize and to empower citizens to gain more control over the personal data. So basically, we want to encourage French citizens and European citizens to take charge of the digital destiny. And as a reminder of the French Revolution, we said that eBestie was quite a catch for a dedicated initiative. So we thought also that the role of association of NGOs in the framework of the collective action mechanism, which is obviously allowed by the GDPR, is also to remind data controllers that processing of a large number of personal data, well, when you do that, you need to basically to uphold the right of the users. And it's a way to start such an initiative, to try putting an end to unethical practices and, well, for example, I don't know, I'll try one, to to limit the term of use that are so long, so complicated, and sometimes so intimidating, to read. Not sure who ever read term of services, but I mean, I did a bit, but still nobody is doing it. And so we prepared and we issued a formal notice with lawyer, researcher, and user based on the work of observation and collecting of complaints directly from internet users. So as of the recruiting process, the BEUC initiative tried to uphold a bottom-up and inclusive way of recruiting the mandate. So basically we published a website allowing any data subject really to post what we called e-doléance. Basically, it's a sort of grievance that you can notify to the BEUC initiative. So you describe the problem, you try to explain what happened, and obviously we received quite a lot. And the idea basically was to study, and we did the e-doléance, and to see what was going on in the community. Basically, what citizens, what other NGOs, what people basically said about it, what was the problem, and which company, which public administration, which data controller was the more problematic. The formal notice against Facebook was issued on November 8th last year, and we focused on particularly 8 main issues. Under the law, as you know, the company has 4 months to respond before one can take action and go to the civil courts, for instance, the Tribunal de Grande Instance de Paris, which is the first degree court for civil complaints. So very quickly, the 7 grievances that we identified was basically one relating to security and basically the effectiveness in protecting and securing personal data for the member of the social network. The second one was on information. A lot of people talked about it, and well, it's basically not being properly informed of what was done with the data. Then we had a lot of problems with non-members cookies. I mean, transfer, collecting data from non-members. People shedding light on fingerprinting and so on. Quite interesting also. We had, but as my colleague from the Quadrature du Net, an important response on term of services, which were hidden behind clicks and so on. Oh, sorry. So term of services, long, complicated, and hard to find. Also on sensitive data, we required, as the mandate told us to, we required Facebook to inform us a bit more on what was done with it. And lastly, how to explicitly, partially oppose the processing of data. That was the last point that we wanted to shed in the complaint. That's about it. I'll get back to there.
Okay, thank you, Lucien. I think it was also interesting that you talked a little bit about this bottom-up strategy that you have in order to find who you're going to complain about, but also just to have an idea about what are the grievances actually of the data subjects of the citizens. And it's also interesting as a recruiting process, so I'm sure there will be some perhaps questions from the audience about it later. But without any further ado, I will turn to Alexis, Fitzjean, or Coffee from La Quadrature du Net, because this is like the star, perhaps, with their first GDPR fine of the CNIL, 15 million euros against Google, and that was all started by this initiative that he is going to talk to us about.
Thank you, Julien. So, to give you a bit of context, on last May 28, we, with La Quadrature du Net, which is a French NGO, on behalf of 12,000 people, we filed 5 complaints before the CNIL, which is the French Data Protection Authority. against several enterprises like Google, Facebook, etc. So in the meantime, the French DPA decided it was qualified to handle the complaint, that it was competent to handle the complaint against Google, while our other complaints against, for instance, against Facebook and so on, were addressed to the Irish and Luxembourg authorities that are competent to handle those complaints. Another complaint was submitted before the CNIL from our against Android from our by our friends of the Austrian NGO Not of Your Business, NOIB, which is the NGOs of Max Schrems. And a few days ago, on January 21, the CNIL finally sanctioned Google to 50 million euros fine, stating that the targeted advertising it engages in with its operating system Android is in breach of the GDPR. However, for us, this sanction is only the beginning, because we are still waiting the CNIL to answer our other complaints against Google, because we didn't specifically targeted the Android operating system, but several other services, Google services like Google Search, Gmail, and YouTube, and those complaints are still pending before the CNIL. $50 million fine is, for my knowledge, the bigger fine in France, maybe in Europe, but at least in France, on those subjects. But it might also be viewed as kind of low compared with the 110 billion US dollars revenue of Google each year. For a quick reminder, the GDPR maximum amount possible is 4% of global revenues, so almost maybe a little more of 4 billion euros. But the CNIL explains in its decisions that the low amount of the sanction, by the fact it limited the scope of its examination to, and I quote I quote the decision, the data processing covered by the privacy policy presented to the user when creating their account on their Android mobile phone. So it limited the scope of the sanction. Maybe a little words on the sanction itself and the legal basis, if I still have some time.
Still have about a minute.
Okay, so very quickly, regarding the substance of the decision, the CNIL sanctioned Android operating system on the basis of two things. The first thing is that the information Google provides when you create an account is not clearly accessible, and the second thing is that our consent is not explicitly obtained with a positive act on our part, but using a preticked boxes, which is explicitly prohibited by the GDPR. It's a good thing, but what we would like the CNIL to do is to answer our other arguments on the freely given consent, the idea based on the GDPR that your consent must be freely given to be truly given. Thank you.
Thank you for this presentation. Now we go on to the next very tricky question, which is how do you quantify the harm that has been done to you because your data protection rights have been breached. Of course, you can have indirect harm, so which is harm caused because that couldn't have been caused if your, I don't know, data hadn't been leaked or if your data protection rights hadn't been breached. But like, how can we quantify this? And can we quantify the harm done by a simple breach of data protection rights? So first of all, Nick McAleenan is going to talk to us a little bit about this, because the claimants that he's representing are asking for compensation, and so yes, he will talk to us a little bit about this tricky question.
So obviously in Morrison's, if the Supreme Court say no permission is granted for another hearing, then we move on to a quantum hearing. So the court will then decide, well, how much should all of these people get in compensation? And what it'll have to do is it'll have to listen to their witness evidence, and obviously consider the facts of the case. And in this particular case, it was a deliberate leak for which this company is legally responsible, and it's going to have to listen to both parties and form a view as to how much should be awarded to these claimants. Now, in kind of inter-party correspondence, when you're dealing with these type of cases in the UK, you tend to refer to one of these three cases in probably 9 times out of 10. Historically, the kind of the go-to award that people would talk about in data misuse, data breach cases was the Halliday case from 2013, and that basically related to an inaccurate credit reference. And in that case, the claimant was awarded £750, which is obviously not it's not exactly a life-changing amount of money. And so often, even today, if you're engaged in inter-party correspondence with a defendant, often they'll cite that particular case and say, well, look, regardless of what's actually happened in this case, this is the most that you're going to get. Here's your offer of £750. But as the jurisprudence has kind of developed, there's been various other cases which have had to grapple with this issue of how much should people be awarded in non-compliance with data protection, but also breach of privacy and breach of confidence cases. And another case which is regularly cited is the Galati case, and this is all to do with hacking into people's voicemail messages by journalists, which was a big scandal in the UK. And in the Galati case, essentially what the court said was, well, in quantifying these damages, you've got to look at the subject matter, what was actually exposed, and what was the effect on the person. Did they suffer kind of shock, or has this been kind of lasting distress that they've had to go through? The damages could perhaps be claimant specific. So if it affects one claimant in a more serious manner than another claimant, then the person who suffered greater harm should perhaps recover greater damages. And also, how many incidents are we actually talking about here? Has it actually, in the phone hacking cases, what was happening was journalists were basically ringing into celebrities' voicemails and listening to their messages to find out, what was going on in their life, what was going on in their love life, what was going on in their health, big issues of public interest, and so on. And so in cases where they dipped in, not often in some cases, it was many, many occasions, those people were, come the quantum award, awarded a greater amount of damages. So in data breach cases, the question is whether or not to refer to Galati, and then also a case of TLT, which I've got on there, which is all to do with accidental disclosure of data. And I think one of the interesting things to come out of that is whether or not it's actionable per se, i.e. whether or not you can get damages without even suffering any upset and distress, i.e. for the technical breach, so to speak.
Thank you. So Lucien is going to say a few words to try and keep time for Q&As at the end. So a few words about how IBEST is going to quantify the amount of compensation it is going to ask from data controllers in breach with the GDPR.
Thank you, Julien. Indeed, we are out of time, so I'll be very quick. So, as I said, in the bottom-up kind of way, the association and the lawyers consider the grievances, and if not, obviously, refuted by Facebook, we evaluated the damages could be compensated by up to 1,000 euros per person. So this could represent quite a lot. If 100,000 people will be to join the lawsuit, well, it's 100 millions, obviously, to be demanded of Facebook. So it's quite interesting. I'll be quick. The main objective, obviously, of asking for 1,000 euros was let's say, to empower citizens through this collective action mechanism and to raise awareness, to improve somehow the powers of the citizen to put pressure on data control, obviously Facebook, but also on the Data Protection Authority, so to speak. 1,000 euros, in a quick few words, basically we studied case law from the consumer case law, and since we have 7 grievances, we evaluated it and in function of the breaches that we described earlier.
Okay, thank you. And then Alexis, Fitzjean or Coffee is going to say something perhaps a bit different and wonder whether asking for compensation is the right way to go.
Thank you, Julien. Well, actually, we think that it's not the right way to see those very important topics, because it might create the idea that you have some kind of a right, a property right on your personal data, but it's not the case, and it would be dangerous if it would be the case, because you might be able to sell your personal data, and we don't think that selling your personal data is a good thing, because for actually a very simple reason is that if you read at the GDPR, the first paragraph is providing that the protection of natural persons in relation to the processing of personal data is a fundamental right. And I don't think that you can sell a fundamental right. So that's basically why we think that it's a bad idea to quantify the damages in relation with the misuse of personal data.
Okay. Perhaps we'll have some reactions quickly, but in order to enable us to have these reactions, I will have to ask our 2 last speakers about the cross-border elements to be actually very brief and just summarize as much as you can what were the cross-border elements and questions raised in your projects. So first, Karolina Iwanska is going to say a few words about cross-border elements in the project that she talked about.
So in my view, collective actions are even more powerful when they have a transnational character, because in this way they can address truly systemic issues. And our case also has a transnational character, because similar complaints have been brought before the Irish and the British data protection authorities in September 2018 by Open Rights Group and Brave, the browser company. And so we joined them on Monday before the Polish DPA, asking the DPA to join proceedings before the Irish and the British DPAs. Because thanks to GDPR, cooperation between national DPAs is not only a right, it's an obligation if it concerns people not from just one country. And systemic issues in this way, I think, can be addressed in a more effective way.
Thank you. And then Alexis, perhaps very few quick words on the cross-border elements in your case. And also, could you, how was it possible also to represent data subjects from other European member states in your case?
Yeah, Okay, so very quickly, basically what the data protection authority did, the French data protection authority did, was to talk with the other DPA, the European DPA, specifically the Irish one. Because as you may know, the GDPR establishes something called a one-stop shop mechanism, and with a lead DPA. And so what happened in our case, as I said earlier, that it was that the major part of our complaints was sent to the DPA, the Irish DPA, and the French DPA just kept the Google one because they considered that Google didn't have a main establishment in Europe. So a few days ago, Google changed its terms and conditions, and they are trying to create a main establishment in Ireland, so to try to help the Irish DPA to stay competent on those topics, because they rather go before the Irish DPA than the French DPA or other European DPA for that instance.
Yeah, so thank you very much. We have a very distinct audience, that means you. So we have heard several expected comments, I would imagine, but also some provocative statements. So we wonder whether you have questions, and if so, we would like to take 3 at a time. Yep.
So if you can queue up to the microphone here, and then we'll take the first 3 questions.
Yes. Hello. Oh, wow. Okay. Yeah, here we are. My name is Stijn Wisman from the Vrije Universiteit Amsterdam. I have a question for Alexis about his statement about being able to redress harms in this case. I drive a bicycle sometimes. Sometimes I ignore a red light. If I would drive into you and your leg would be broken, do you think that the prohibition on slavery would stop you from holding me accountable?
Okay, thank you for. We'll take 3 at a time.
Okay.
Thank you for this provocative question.
Hi, it's Pat Walsh, Privacy Matters. There's 2 things, if I can. One for Nick. I'm perplexed that they were only found vicariously liable because there seem to be some issues with multi-factor authentication and a failure to adopt that at Morrison's. But that breach occurred under the old Act, and your global litigation order proceeded under the old Act. How has Article 80 changed it, and what difference would it make? And then in relation to all of you, the NGOs, great job's being done. Have you developed tools that allow you to conduct technical analysis in a way that can be standardized and would stand up to scrutiny in court?
Okay, thank you.
Hello, for me, I'm Jordanka Ivanova, PhD student writing on GDPR. So my first question is to Karolina, and the action that you have just brought. I was interested, what are the legal grounds, like what are exactly the violations that you claim in your action that this big data and Google in its recommendation is in fact infringed. And my second question is maybe to Maryant, as the representative of the consumer organization. How do you see, in fact, this combination between consumer protection and claiming damages for unfair practices and also the data protection? Do they overlap? And the quantification of damage, have you had some experiences or already ideas how you could, in many cases, you could have unfair practice and a data protection violation already? So maybe just your thoughts on this. Thank you.
Thank you. So, it's like a very short question.
Okay, I'm Stuart Tresner from Privacy Laws and Business. My question is that there's a case going on between the consumer organisations of Belgium, Spain, Portugal, Italy, France, possibly, and others I can't remember, perhaps one in Germany. So I wanted to ask the chairperson from BEUC what's happening on that case, because it's not been mentioned here. It's been going a long time. They're running on the Belgian website. They've got a counter of how many people are joining the case. I think the amount of damages sought was rather less than €1,000, but it's the principle obviously involved. And the second point is we ran a workshop, an official side event for the Commissioners' Conference in Brussels in October 24th with speakers from BEUC and others, consumer organisations from Germany and commercial lawyers, and we can make available all those papers and slides from that conference to anyone here who's interested. If you come to me later, give me your details, which we will use for sending you the information about that conference, and you can opt out any time, and that could be useful with a lot of extra material. So there's 2 points there. Thank you.
Yeah, thank you very much. So first question was for Alexis.
Yeah, and my answer would be very quick because I honestly don't see the link between the slavery and the harm causing by a bicycle, so I'm sorry, but I can't answer your question. But I'd be very happy for you to explain to me further, maybe after the conference, if you would like to explain what you meant about that. But what's the link between the slavery and?
We'll have to keep the bilaterals for the lunch or for the cocktail. So yeah. Okay. So the second question was for Nick. What would Article 80 change for you?
Just going back to the last question, if I could chip in very quickly. I mean, in the UK, you get damages for the upset and distress that was caused by the non-compliance with your rights, and then also the loss of control potentially of your information. That's how the UK would possibly analyse some of those situations in terms of quantifying damages. In terms of the Morrison's case, I think the first part of the question was, hang on a second, didn't they actually infringe the Data Protection Act in various other ways when you consider the facts of the case? I mean, essentially, we ran those arguments before the High Court, and we said, well, if you look at their practices and look at what has actually happened in this particular case, they were passing around unencrypted, possibly. The court said it was on the balance probabilities probably encrypted, USBs, over 100,000 people's sensitive payroll information. The court said essentially that in itself did not cause the data leak. The issue here is causation. Did what Morrison's do or not do actually have any causal link to the upset and distress and so on suffered by the victims of this data breach? So there were a lot of criticisms that we raised in the direct liability arguments, but we lost on those points, save for the issue of data deletion, where the court said, okay, you didn't have a proper fail-safe system in place. We're criticising you for not complying with DPP7, and you're quite right, it's all under the old act, so to speak. There's now the new Data Protection Act 2018. But notwithstanding that, that didn't have any causal link to the suffering of the victims, and therefore there's no viable action here. And that, I think, is a really important area of learning for other collective actions. Can you actually show that even if you've got criticisms of the company, and there's all sorts of things that we know about Morrison's systems. Morrison's has got us to sign very, very restrictive and draconian undertakings so that we're not allowed to talk about what we found out about Morrison's systems. But it's all there in the transcript of the hearing if you'd like to pore over it. So that's the first part of that particular question. And the second part of the question was, would Article 80, would GDPR changed anything in particular? I don't think it, I mean, from the collective, I mean, it might have been the case, obviously, that an NGO could now bring this type of an action, but as the other speakers have already identified, NGOs have quite little appetite to take on thousands of and manage, because it's extremely time-consuming and burdensome, having thousands of clients on their books. I think what it would change GDPR is obviously there's greater obligations in terms of transparency and so on, and proving that your systems are up to scratch. And so this that's something that might now be relevant in future data breach actions.
Okay, thank you. So we have this question for any NGO about standardizing tools. Who would like to answer that question?
I'm not sure if I can answer this question because we haven't done any collective actions, and I think this is one of the reasons why we are not doing this. It's because this standardizing is really difficult, and I would really love to hear from the Quadrature, for example. How do you even recruit the people to have a collective action? How do you collect mandates from them? If that was your question was about.
No, it's more about.
Sorry, but we only have.
But just.
But they didn't understand the question.
Oh, okay.
Yeah.
Oh, sorry. Yeah, so then you can.
So
Yeah.
this is like the fact that you've done analysis, whether it's on Android or whether you looking at the behavioural, about the data that's being harvested and collected and used. You must have had some computer scientists helping you at the technology level doing that analysis. So have you created a consistent approach and a standardized approach to doing that amongst NGOs?
No, but this is definitely a goal that we would like to do, especially that we are encouraging other NGOs to join us in our complaints. And we are obviously, our materials are in Polish, but one of the attachments to our complaint is a technical report by Johnny Ryan from Brave, which is publicly available at Brave's website, and it describes over around, I think, 20 pages, because I think it cannot be described shorter, how auctions work and what exactly is wrong with that. So I think that if other NGOs are interested in filing complaints against this particular industry, they could use information from that report.
There was still.
And there was also a question about the legal principles of our complaint, where this is a very systemic complaint. So it addresses the entire ecosystem and of online behavioral advertising. And the two main issues is, well, transparency and control. So once the personal data is broadcast during a bid request at ad auctions, the company that broadcasts it, so usually the publisher or the so-called supply-side platform which acts on behalf of the publisher, loses control over that data and has no way, and as a result of that, as a consequence, has no way to give accurate information to the data subjects themselves. So if even the publisher doesn't know where the data will eventually end up and how long it will be processed, because all the limitations are only contractual, and in fact we are as users are, and also people who work in this business are not aware of the fact whether, for example, an 18-month-long limitation on the processing period, how and whether it is enforced. So, and also data subjects do not have access to this information, as our investigation over the past year has shown. There is no way to access this data, to have truly comprehensive information of how it's processed. And this is not incidental, these failures. They result from the very design of these ecosystems. So our main concern is the issue of privacy by design. And the ultimate effect that we would like to achieve is a complete redefinition of these ecosystems. And I can see, and we argue, in fact, that Google and IAB, because of the fact that they create standards for these ecosystems, are in fact controllers. In the light of the Wirtschafts Academy case and Fashion ID, we think that it's the concept of controller is getting broader and broader, and I think we have a good chance to argue that as well.
Okay, thank you. And so now for the two last questions, I'll pass the floor to Maryant, Ferna from BEUC.
Thank you. And as a chair, I also have the benefit to conclude, so you have to bear with me. Briefly, we see that consumer law and data protection law as complementary. Of course, consumer law, like for example, through this new initiative of the proposal for a directive on representative actions, there might be some limits, but we're working hard to get the best outcome. So even before the GDPR, our members have been very active. So for example, UFC Fitzjean, before the GDPR, actually managed for the Tribunal de Grande Instance in France to order Twitter to remove 250 clauses, including data protection-related clauses. So this is a big victory, and this shows that things can be done. With regards to what's happening with the current cases, I can speak well, very briefly, because we have 1 minute. So one, the Swedish Data Protection Authority has already accepted, sent a questionnaire to Google in the complaint against Google location tracking. However, the Norwegian DPA is hesitant on the competence with regards to the case, and then we expect the case, especially with regard to the competence, to be referred to the European Data Protection Board. And finally, I want to react and also address the question about whether giving compensation to consumers would actually amount to giving them property rights. Actually, BEUC and our members are against this approach. But it's important to remind one thing. Collective redress, first of all, will not lead to abusive litigation. I hope that with all the projects that we've seen today, you can see that. It's about having redress for potentially illegal profit. It's about actually ensuring that companies stop damaging consumers. It's an incentive for companies to comply with the law. It's an incentive for better performance and to address imbalances in the single market and also to ensure a level playing field. And I want to conclude with what I said in the beginning, namely that we need to overcome the myths and really come to facts. Fears can be overcome by safeguards. And then this can be shown in many ways. I actually like one particular fact that, for example, collective redress is available in Portugal since the 90s. And until now, out of all of the actions brought by our member DECO, do you know how many were discarded by the judiciary? Take a guess. 0. Right. So it's important to understand that this is important for consumers. The GDPR brings some possibilities that are trying to be used by NGOs in good faith, but we need more, and that's why BEUC is working on the directive for representative actions. Thank you very much, everyone.